All right. Good evening, everyone. Good evening, everyone. And welcome to Everything Legal Lounge. Welcome back to Legal Lounge. I am Chukwemeka Philip, the founder of EL Everything Legal. And this is Everything Legal Lounge. I believe, I believe for the old members, you must have witnessed episode 1, episode 2, and episode 3. Now, this is episode 4 of Legal Lounge. And on today's section, we will be looking at a very important topic in civil litigation, and that is appeal. We're looking at appeal in civil litigation. Now, before we get to appeal, I would briefly tell you all what Legal Lounge is all about. Now, Legal Lounge is a program powered by The purpose of Legal Lounge is simple: to enable students of the Nigerian law school, aspirants to the Nigerian bar, excel in the bar exam by simplifying basic subjects, topics in different courses relating to the Nigerian law school, and of course, excellence in the bar exam. Yes, and Legal Lounge holds every weekend, Saturdays, 7 p.m. Attendance is completely free. Participation is free of charge. So this is to reach out to as many students of the Nigerian Law School as possible to enable you all excel and approach the bar exams with confidence. Now, there is a problem of fear always associated with the Nigerian Law School and the bar exam. Students are always afraid, scared of the bar exam. And the reason for this fear is borders on confidence. Confidence is not just mental, it's also on preparation. The more prepared you are, the more confident you become. And this is one of the things we tend to achieve in Legal Lounge. This is one of the things we tend to achieve in Legal Lounge. So, welcome to episode 4 of Legal Lounge. I'm happy to have you all here. Now, we would go straight to the business of the day. And the business of today is appeal in civil litigation. The business of the day is appeal in civil litigation. Civil litigation is one of the courses offered in the Nigerian law school. And the topic we'll discuss today is appeal. Now, before we get to appeal, your understanding of appeal starts from judgment. I repeat, your understanding of appeal starts from judgment. And basically, judgment is the final determination of rights, duties, and obligations of parties to a suit. I repeat, judgment is the final determination of rights, duties, and obligations to parties to a suit. So the final determination of rights, duties, and obligation is judgment. Your understanding of judgment give rise to your understanding of appeal. Now, in judgment, there are two concepts you must not forget. In judgment, there are two concepts you must not forget. One is judgment itself, and the other is ruling. I repeat, one is judgment itself, and the other is ruling. Now, for judgment, judgment is the final determination of rights, duties, and obligations of parties to a suit. On the other hand, ruling is the determination of the court upon hearing an interlocutory application. Ruling is an interlocutory decision of a court. To understand appeal, you must be careful to get the difference between the final judgment and ruling. The judgment itself is the final determination, while ruling is an interlocutory decision. interlocutory decision of the court in a suit. Now, having known what judgment is, it's because after judgment, we go to appeal. You cannot understand appeal. Now, having known what judgment is, let's get to the topic appeal. Before I give a definition of appeal, what you must understand in appeal would take you back to the relationship between an apprentice and his master. I repeat, for us to understand appeal, I would take us back to the relationship between an apprentice and his master. Now, an apprentice stands in the shop or the establishment of the master where the master is not around. And as such, an apprentice can make decisions, take decisions with respect to that business, which includes sales and delivery of goods. Let's give, for instance, the establishment is focused on delivery of goods, sale and delivery of goods. Now, an apprentice can act on behalf of his master. And when a customer is not satisfied with the actions of the apprentice, the proper thing is that the customer invites the master to determine the propriety of the action of the apprentice. I'll repeat. To understand appeal, we give you a basic relationship between a customer, an apprentice, and the master to the apprentice. Where a customer is not satisfied with how he was treated by an apprentice, the customer relates that issue to the master. Thank you very much, Adam. God bless you too. The customer relates that issue to the master, reporting what? The incident with the apprentice. This is what happens in appeal. For you to understand appeal, just understand this basic concept between a customer, an apprentice, and his master. Now, let's get back to the definition of appeal. We are coming to civil litigation. I believe we have made progress from this point. Now, appeal is an invitation. I repeat, an appeal is an invitation to a higher court to review a decision of a lower court. I repeat, appeal is simply an invitation to a higher court to review the decision of a lower court and establish whether that decision is right or wrong. That's basically what appeal is. It is an invitation to the higher court to review the decision of the lower court, basically to establish whether the decision of the lower court is right or wrong. And I take you back to the illustration I gave with a customer, apprentice, and the master. Now, the customer is not happy with how he or she was treated by the apprentice. And that customer invites the master of the business to review the action of the apprentice. That's basically what happens in appeal. Now, please, class, I am not calling the lower court an apprentice. I'm not calling the higher court a master. This is an illustration to make you understand the concept of appeal, right? The lower court is not an apprentice, right? And the higher court is not the master. But you must know this. In Nigeria, there is judicial precedence and hierarchy of court. Now, because of hierarchy of courts, higher courts can always review decision of lower courts. That's the position of hierarchy. And an invitation to a higher court to review decision of a lower court to establish whether a decision is right or wrong is appeal. That's what appeal is all about, as simple as that. Now, for the bar exam, you see, I always tell you in class that you are concerned with not just reading, but application of what you have read in painted scenarios. Now, for the bar exam, the appeal we are concerned with is appeal from the High Court to the Court of Appeal. I repeat again, For the bar exam, what we are concerned with is appeal from the High Court to the Court of Appeal. So you have no business, for students preparing for the bar exam next month, you have no business reading all the principles of appeal from Court of Appeal to Supreme Court for civil litigation. You have no business reading appeal from Magistrate Court to High Court for civil litigation. You don't need all that. What you need to know is the procedure of appeal from the State High Court to the Court of Appeal. Please, that is what you are concerned with for the bar exam. Now let's make progress. You must know this. Appeal is a constitutional right. I repeat, appeal is a constitutional right. Don't forget, the Constitution of the Federal Republic of Nigeria empowers parties to appeal. And this is called right of appeal. I repeat, this is called right of appeal. Right of appeal is established by the Constitution, and it empowers parties to invite higher courts to review decision of the lower courts. That is right of appeal. And let's break this confusing concept. There are two confusing concepts here. There is difference between right of appeal and appeal as of right. I repeat, class, we must be careful to distinguish between right of appeal and appeal as of right. Now, right of appeal, as I've said, is a constitutional right. Appeal is a constitutional right. The empowerment of the Constitution to parties to appeal is known as right of appeal. Then, on the other hand, appeal as of right is a type of appeal where the parties would not need to seek the leave of court before filing the notice of appeal. I would repeat this again. There's a clear-cut difference between right of appeal and appeal as of right. Now, class, right of appeal is the right that empowers parties to appeal where they are not satisfied with the decision of the court. And this right was given in the Constitution. It's embedded in the Constitution of the Federal Republic of Nigeria. This is right of appeal. And right of appeal is different from appeal as of right. Appeal as of right is a certain type of appeal where these parties would not be required to seek the leave of court before filing the notice of appeal. Please take note of that. This is the difference between right of appeal and appeal as of right. Now let's come back to right of appeal. I was saying something important. I said appeal is a constitutional right. The Constitution empowers parties that are not satisfied with the decision of the court to invite a higher court to review the decision of the lower court. This is right of appeal. And under the Constitution, there are persons that have right of appeal. I repeat, under the Constitution, there are persons that have right of appeal. Number one, the parties to the suit. I repeat, number one, parties to the suit. Both parties to the suit have a right of appeal as established under the Constitution. Both parties to the suit have rights of appeal. Number two, interested parties. Number two, interested parties. Now let's establish who interested parties are. Interested parties are not originally parties to the suit. I repeat, interested parties are not originally. Repeat, they have right of appeal as interested parties. As interested parties. Take note of that. So number one, both parties to the suit have right of appeal, and number two, interested parties have right of appeal. I think the case of Akim Bunu and Oseni